hope it's good.
There we go.
Awesome. There we go. Well, hello. Welcome. Welcome. So I would like to introduce the F&I members to Shay Nelson. She is my business lawyer, and she helps me sort out all those dealings that us as nurses don't understand. And she keeps me out of trouble. And so we were talking recently about different things that a couple of F&I members were interested in learning about. And we're going to do a webinar on trademarking. And so I know that we've had a couple nurses who have been entertaining the thought of trademarking. And as I've discussed in the course, I trademarked my first company, Everyday Divinity. And after spending extensive amount of time trademarking that myself, I opted to not trademark the F&I system myself, and I turned that over to somebody who understands it a lot better than I do, because I wasted a lot of time trademarking on my own. And I am very appreciative of the services that you provided in trademarking, and you took that off of my plate. So I'm going to turn it over to you and let you go ahead and take the platform here and explain and teach us what we need to know about trademarking. So welcome, Shay.
Awesome. Well, so happy to be here. Always happy to help out. I know that F&I trademark turned out to be a little bit more interesting than we thought it would be. But let's dive right in. So trademark is all about branding. Okay, that's the big thing to keep in mind. So today we're going to talk about how to protect your brand. Now, before I do that, the ethics folks always want me to throw in this reminder. Of course, we're going to be talking about general information and best practices, right? But that's not the same thing as actually sitting down and forming an attorney-client relationship, whether that's with me or some other attorney that you know, like, and trust. That's a really important conversation to have. The best that we can do in a presentation is always going to be general rules, best practices. But the thing that's so fascinating about the law, at least for us attorneys, is that there's a lot of gray area and a lot of exceptions to every rule. That's also the thing that drives our clients crazy. And the reason why the answer 90% of the time is it depends. So we're going to talk about the general rules and best practices, but there's a lot of nuance here that we're just not going to be able to get into in 30 to 45 minutes.
Mhm.
So today we're going to talk a little bit about why I think it's so important for entrepreneurs to consider protecting their brands. And then we're going to start talking about the process itself. So why it is that your attorney is going to say, hey, let's sit down and start with a trademark search before we file any paperwork. And then we're going to talk about the registration process, and time permitting, we'll talk very briefly about what you need to know to maintain your trademark rights. And I'll talk a little bit about, if you're listening to all this and you're going, okay, I don't have the time, I don't have the money, or that's not at the top of my priority list, what then? What happens if I don't register, if I can't register? So we'll talk about that as well. So before we dive in, let me start with just a really brief overview of intellectual property, because people tend to get these concepts mixed up a lot. So when we talk about intellectual property, you've got a couple of different things. You've got copyrights, you've got trademarks, you've got something that we call trade secrets, and then very briefly, you've also got patents. So what's the difference? When you're thinking about copyright, think about content, right? Copyright gives the owner of that copyright the exclusive right to do certain things or give other people permission to do things with their content. So we're talking about making copies, making derivative versions, distributing copies of the work, performing the work, even playing recorded music out loud, displaying the work. All of those things fall under copyright. So for example, when you're on social media and you see somebody go, hey, I don't have the rights to this music, that doesn't make it okay. That just means they're admitting that they've infringed someone else's copyright because they didn't have the right to copy it or produce it or display it or perform it. When we talk about trademarks, however, we're talking about branding, okay? And that's really, you have to think of it as a distinctive word, phrase, a logo, or a graphic symbol that identifies the source of your products or services and distinguishes that from those of your competitors. So with copyright, you can protect content, but you can't protect short titles or names or very short phrases or slogans. Those things you're going to start to protect with trademarks. So remember, when you're thinking about trademarks, just think about branding. Now, trade secrets is this idea that there are certain things that are really valuable in your business, and they're valuable precisely because the general public and your competitors don't know them, right? They're valuable precisely because you've been able to keep them a secret. And those types of things will generally be protected with a combination of both written confidentiality agreements, like your standard non disclosure agreements, as well as making sure that that information is only available on a need to know basis. And then lastly, whenever you think about patents, think about inventions, right? You've actually physically created something new. The law will give you some property rights in that thing that you've created. So that's kind of the difference between those. So today we're going to focus on trademarks. So like I said, trademarks is all about branding. If your business, if your marketing plan is all about investing in a brand, right? Building up this brand recognition, building up customer loyalty, building up that goodwill, then it's important for you to protect your trademarks, okay? If we go into, the sporting goods store, the shoe store, right? We all probably have some preference between Nike versus Adidas versus Reebok versus whoever else, right? And a lot of that comes down to branding. If we all pull out our smartphones, right? We've all got our preference between, team iPhone and team Android. Again, that comes down to branding. We have a preference between Apple and Samsung. That's what that's all about protecting. Trademark rights give you the exclusive right to use your particular trademark in connection with certain goods and services so that nobody else can use that trademark. Now, there are a couple preliminary requirements that have to be met before you can actually get a trademark registration. So the first is that your trademark has to be distinctive. And secondly, it has to be used in interstate commerce, which is just a fancy way of saying you've actually got to be selling your product or services across state lines. The distinctive piece is a bit more important, though, because remember, the trademark is all about differentiating your products or services from your competitors. And so trademark law can be a little bit tricky for people to get their heads wrapped around because the law protects things that are incredibly unique, things that you have to actually put some work into building up brand recognition for. Whereas most people, when they're thinking about marketing, they want something that's easy, something that's obvious, something that people are going to look at it and go, I know exactly what that product is, or I know exactly what that service does and what it's about. So on the one hand, we've got things that generic words, right? Those things are never going to be protected by trademarks, right? If I'm a farmer and I go out and say, okay, I've got, apples, right? I'm never going to be able to trademark apple for my apples, right? That's a generic word. In the same sense, historically, we've seen things that started out as trademarks and then eventually lost their trademark significance because they became generic words. So, for example, aspirin was once a trademark of Bayer, but that's now just a generic word for aspirin. Similarly, escalator was once a trademark of Otis Elevator, but now that's just what we call those rising stairs, right? And that's the reason why companies like Google don't want you to talk about, well, just Google it, as in, go do a search on any site on the internet, right? They really want that to just reply to going to google.com and doing a search. So you can't trademark generic words. That probably makes sense. The next level up, and what we tend to see a lot of entrepreneurs do, is they come up with something that's descriptive, right? It describes something about their goods or services. Doesn't really take a whole lot of creative genius to kind of figure out what they're talking about. And when it comes to words and phrases like that, the law says that they're really not protectable unless they acquire distinctiveness, which is just a way of saying they start to become a little bit more famous, right? So common examples, the History Channel. If you were just starting that as your YouTube thing and you were just, Joe Smith that nobody had ever heard of, you probably wouldn't be able to get it trademarked. But if it takes on some fame, now let's say the History Channel, you know exactly what channel we're talking about, right? Then you probably can get it trademarked. Trademarks like that often end up starting out on the supplementary register, which is kind of like it's not the full trademark register, but I'm reserving my rights in it. As we build up that brand recognition, we build up some of that fame, then later on we can look at moving it to the primary register. So you've got generic, you've got descriptive, right? Maybe eventually you'll be able to get that trademark. And then you go up to what we call suggestive trademarks, right? They hint at something about the product or service, but they don't spell it out directly. And so because of that, it requires a little bit more creative thinking. The law will protect those. So for example, Microsoft for computer software, right? It doesn't explicitly say that, but you can kind of think, okay, I see where they got the soft from. I can see where micro came from, right? We're starting to hint at what that software does. If you think about suntan lotion, right? Copper tone, right? Copper tone doesn't explicitly tell you anything about suntan lotion, but okay, I can see where they got copper from, toning. Okay, I see what you did there, right? So those are the suggestive trademarks. The next level up, even better, arbitrary trademarks, right? This is when you take a real word that has a typical common meaning, but then you use it in a way that's completely arbitrary. So when we talk about Apple for computers and iPhones, right? Real word used in a completely arbitrary way. Those things are going to be entitled to a lot of trademark protection. And then the top level, the very best trademarks are going to be what the law calls fanciful trademarks, right? So you have just completely made up something. So for example, Exxon, completely made up word, but because they put the effort into the brand recognition, you know exactly what I mean when I say Exxon. Or for those of us that remembered cameras before smartphones, Kodak, completely made up word, right? But now we know what that means because of the effort and the work that they've put into building up that brand recognition. So I know when you're talking to your marketing person, you're thinking, okay, I want something easy. I want something catchy. I want people to look at it and know exactly what it's about. But really, you want something that's more suggestive or arbitrary or fanciful so that you can start to think about that trademark protection. Yes, you're going to have to put in the work to help customers understand what it means, but by doing so, you're going to have something that's way more valuable as you grow your business. And then, like I said, we talked about the use in commerce, and that's just a fancy way of saying that before you can get a registered trademark, you do actually have to be selling your product or service. And we'll talk about that a little bit more.